All right, let's dive into one of the most confusing and frankly stressful parts of the legal world. What happens when you get a court decision that you just know is wrong? Today, we're drawing a map for that journey.
So, picture this. You've been through the whole court process. The judge has handed down a verdict, and you're sitting there just thinking, no way, that's not right. It's a gut-wrenching feeling, and it immediately brings up a huge question. Now what? Well, it turns out the story might not be over.
You see, the whole idea of an appeal is basically a safety net. It's not about just dragging things out for the sake of it. It's a fundamental part of the justice system, designed to catch mistakes and make sure the final outcome is as fair as humanly possible.
Okay, so who gets to use this safety net? It's actually pretty straightforward. The only person who can appeal is the person who lost the case. Now, the system we're looking at today has a specific term for this person, al-mahkum alai, but the principle is universal. But, and this is a big but, it's not an automatic right. If you've already accepted the verdict or you started to pay a fine or follow the order, you've basically waived your right. And obviously, if the court gave you everything you asked for in the first place, you can't really appeal your own win, right?
So, assuming you have the right to appeal, what does that actually look like? Well, your legal roadmap isn't just one single highway. It's more like a major intersection with three very distinct paths you can take, and each one leads to a different destination.
And here they are. First, you've got the standard appeal, which is basically asking for a full-on second look at your case. Then there's cassation, which is way more technical. It's a check for big legal mistakes. And finally, you have reconsideration, which is this extraordinary, almost break glass in case of emergency option.
Before we break down any of those paths, there's one number you have to burn into your memory: 60. For most types of appeals, you have exactly 60 days from the day you get that written judgment. Miss that deadline, and your chance is just gone. The clock is ticking from day one.
Okay, let's take that first road, the standard appeal. In the legal system we're looking at, this is called alistinef. The best way to think about it is asking a higher court for a complete do-over, a chance to argue the facts and the law all over again.
This is your chance to really relitigate. The appeals court isn't just double-checking the first judge's math. They are diving back into the facts. You can bring in new evidence, you can make new arguments. And their decision can be anything. They might agree with the first court, they might tweak the verdict, or they might just throw the whole thing out. It's powerful stuff.
Now, here is the absolute superpower of a standard appeal. The second you file it, it automatically hits a giant pause button on the original verdict. The legal term for this is iqaf tanfid al-hukum. It means the other party can't do anything to enforce that first ruling while your appeal is being decided. It's a huge deal.
Path number 2, cassation or al-naqd, is a completely different beast. This is not a do-over. This is a very specific, very technical challenge that's all about one thing. Did the court mess up the law?
So with cassation, you're not arguing the facts anymore. You're not saying the witness was wrong. You're going to the Supreme Court and saying the judge applied the wrong rule, or there was a major mistake in the procedure that made the whole trial unfair. It's a legal checkup, not a retrial. And you can't just file for cassation because you're unhappy. You have to have very specific reasons. Was the law itself violated? Was there a procedural error so bad it changed the outcome? Is the judge's written decision totally contradictory? These are the kinds of high-level legal arguments that the Supreme Court is willing to listen to. So, does this path also hit that magical pause button? Well, it's complicated. For some really important types of cases, think family law, property disputes, things like that, the answer is yes. It stops automatically. But for everything else, nope. The verdict stays active unless you can separately convince the Supreme Court to step in and order a pause. It's a key difference. And that brings us to our third and final path: reconsideration. The legal term is iltimas iadat al-nazar, and this is the most dramatic and rarest of them all. This is the option for when a case is supposed to be done and dusted, but something truly exceptional, something huge, comes to light. And if you thought 60 days was a tight deadline, get this. For reconsideration, you only have 30 days. And that clock starts ticking the second you find out about the new information.
Talk about pressure. The reasons for this are straight out of a legal thriller. You find proof that the other side cheated. A critical document is exposed as a forgery. A key witness from your trial is later convicted for lying under oath. Or you uncover that one piece of evidence that would have changed everything. We're talking about bombshells.
Now, this is really, really important. Just like with cassation, filing for reconsideration does not automatically pause the verdict. You have to specifically ask the court to stop it, and they'll only do that if you can prove there's a risk of serious, irreversible harm. So this is a very high-stakes play.
And there's a serious financial cost, too. To even file for reconsideration, you have to put down a security deposit, called a kafala. And look how that cost shoots up depending on which court you're challenging. From $25,000 to challenge a primary court verdict, all the way up to $100,000 to challenge the Supreme Court. And here's the kicker. You only get that money back if you win.
Okay, I know that was a lot of information. We've gone down 3 different roads. So let's pull back and put it all together on one simple dashboard so you can see how to choose your next step.
Here it is, all laid out. Your standard appeal is for re-examining the facts and the law. You've got 60 days, and it automatically stops the verdict. Simple. Cassation is for correcting legal errors. You also get 60 days, but it only sometimes stops the verdict. And finally, reconsideration is for those bombshells of new facts or fraud. You have a super tight 30-day window, and it usually does not stop the verdict.
So, what's the big takeaway from all this? It's that you can't just pick a path you like. The right choice depends completely on why you think the verdict was wrong. Is your problem with the facts? You're looking at an appeal. Is it a super technical legal mistake? That's cassation. Did you just uncover a massive fraud? That's reconsideration. Your why dictates your how.
You know, when you look at all these options, the do-overs, the technical checks, the emergency measures, it's really an acknowledgement that the justice system is run by humans, and humans can make mistakes. New information can surface. And it leaves you with this really big, fascinating question. In this whole search for justice, when is a case ever truly, finally closed?